correct me if I'm wrong, but I do honestly believe some things that may not be true.
Do you take reasonable steps to ascertain whether it's true?
That's a good question.
Here we go,
That's
folks.
what we're going to talk about.
Fasten your seatbelts.
Well, we've covered this before. We've talked about...
It's a very complicated issue of law.
Yeah.
It really is.
So we're going to talk about the defense of honest but mistaken belief in communicated consent in sexual assault cases. And we've covered this before, particularly because we had an interesting case where we specifically only argued.
Yeah.
Only argued. We went directly to the issue of honest mistaken belief in consent.
He admitted that in the end, because she bit him, that, you know, he was like, yeah, okay, it became clear to me that she wasn't consenting. But there were a lot of things, including the complainant herself having said I was giving him mixed signals, right? So it was quite an interesting case for us. It was the only argument.
Shall I set it out briefly for our viewers?
Yeah, and just the reason we're reviewing it was there's an interesting article that's come out on this, and it's worth discussion.
I can go now?
Sorry, I didn't mean to interrupt.
You didn't.
I apologize.
Thank you. Okay, here we go, folks. Fasten your seatbelts and listen closely. So this is the defense of honest but mistaken belief in communicated consent.
Communicated consent.
Right. The defense of honest but mistaken belief in consent is codified in Section 273.2, Sub B of the Criminal Code. To make out the defense, and I'll slow down, it must be established that the defendant reasonably believed that the complainant communicated consent, whether by words or conduct. Repeat or pretty clear?
Well, just add to that reasonable steps.
Well, I was getting to that paragraph.
Yeah,
Okay,
there's a
keep
lot
going.
here.
There's
Keep
more.
going,
Oh,
then.
this doesn't end with that paragraph.
You keep going.
It is a precondition to this defense that the defendant took, quote unquote, reasonable steps to confirm communicated consent. This too has been codified in the section I just mentioned. The defendant must take steps that are both objectively reasonable and considering the circumstances known to him at the time. Essentially, this requirement dispenses with the long outmoded notion that passivity, silence, or conduct ambiguity can be equated with the communication of consent. Oh my God, this sounds like a really complicated law school exam question.
I want to inject something here
this.
because you used the word him, which of course sexual assault being committed by either gender.
Thank you for the pronoun correction.
But, no, it's listed as him because of the case specifics in this.
Right.
But I want to point out that you mentioned that consent can be communicated verbally or non-verbally.
Right.
And when a woman grabs a guy's crotch without asking first,
Where are you going with this?
this is considered to be communicated consent for sexual activity, but it's not considered to be a sexual assault by her on him. Right? So I just want to make this point. I want to make this point.
Really?
Because
I've been like...
Hold on, we had this in a case, and there's a reason why
Really?
you're mentioning
Okay.
it.
Yeah,
Okay, 'cause I'm
but
thinking
all
these years
it's
I've been
really
thinking-
interested. I'm really interested in the fact that nonverbal, communication involves the woman taking sexual actions with the man without first verbally checking with him.
Right.
And primarily, most people accused of sexual assault are male, and this onus
Give or
of
take.
this onus of obtaining consent and whether or not their mens rea, which is the
Guilty mind or the mind.
the guilty mind, is satisfied, cannot be satisfied sometimes because they fail to take reasonable steps, even though some of those communicated things are the woman failing to take reasonable steps to ascertain whether or not the guy wanted.
Yeah, I mean,
I just want to make that point off.
It simply just became interesting because we had a case where our client was arguing with the complainant in a recorded conversation saying, well, where did you obtain my consent? Right? When you started doing X, Y, and Z. So it's a valid argument.
You were on top of me. When
Right.
did you ask my consent?
But consent can be communicated through words or actions. But let's talk about reasonable steps for a second, just according to the case law. Reasonable steps will depend on the circumstances of the case. The defendant cannot test the waters by recklessly pursuing non-consensual sexual contact to determine whether the advances are welcomed. The more invasive the sexual activity, the greater care to be demonstrated in ascertaining communicated consent.
Particularly if they're strangers.
That is absolutely correct. To rely on the defense, the defendant must show there's an air of reality to the defense. The trial judge must consider whether there is evidence upon which a reasonable trier of fact acting judiciously could find, 1, that the accused took reasonable steps to ascertain consent, and 2, that the accused honestly believed that the complainant communicated consent. Once this threshold is met by the defense, the onus shifts to the Crown to negative the defense. This could be achieved by proving beyond a reasonable doubt that the accused failed to take reasonable steps. Complicated stuff.
I was going to say that's a
It is,
lot
and that's why
of.
we've touched on it. We've touched on it before, but it's it's hard to wrap your mind around exactly how this works and what the requirements are. And I think it's so important for us to actually dive in a little bit deeper.
Is this case reported? The one that we're reading from? Because this was an excellent.
Yes, it's on Kenley. Yeah.
Okay, so we can say, because this was an excellent case. It's one of our cases. And it's Ontario Court of Justice, but he lays out the defense with facts very, very clearly. It's very well written.
I think, actually.
It's �KQ, and it's a 2022 decision, but I think it's reported on Canley. But it does a very good job of laying it out. So that's
I just don't see the citation now, so I'm just like...
well laid out, but it's a very complex defense.
Yeah.
So here's the issue. Does this shift a burden to an accused that's unfair?
Well, that's one of the things that's in this article that we were looking at that came out too. And they're saying in 1992, Parliament amended sexual assault provisions in the criminal code, and they put in some specifically that the accused must take reasonable steps. Right. And so then how that's interpreted by the courts has been a little bit diverse in terms of, and of course, the problem is that how far can you go with this before you shift the burden of proof?
Right. And how many
where the accused then has to prove that they did take reasonable steps, otherwise they're presumed to be guilty.
And what equals reasonable steps?
Exactly.
How many steps do you got to take before it's unreasonable?
So, so it says in the article, certain sexual offenses in the criminal code, including sexual assault and sexual interference, have long been interpreted as requiring proof that the defendant knew or was reckless or willfully blind to the relevant fact, whether it be consent or knowledge of the person's age.
Right.
However, after the 92 amendments to the criminal code, if a defendant can't point to any evidence upon which a trier of fact, be it judge or jury, may find that they took reasonable steps to ascertain the relevant fact, be it age or consent, that the defendant is barred as a matter of law from raising the defense of mistaken belief. So this is a legitimate defense to say, maybe they didn't consent, but I had no reason to think that they didn't.
And I took some steps.
If that's your defense, you then actually, it kind of does reverse the burden of proof. You then have to prove that you took the reasonable steps. Right. So why is that difficult?
You have to point to real evidence as to what informed your belief that you had honest but mistaken belief in consent and what those steps were.
So that shifts the burden to you, doesn't it?
It does. Now, I would argue, actually, that I think it's fair in these circumstances. If it's fairly clear that the person is not consenting, and in our case, it's pretty clear.
Yeah.
Okay?
This one we're talking about.
Yeah, this one. It was pretty clear. When he made a move, she bit him pretty damn hard.
One would think.
And,
left a pretty serious mark.
and everybody was intoxicated, so it didn't help. But I think it was a clear and valid argument by the Crown that, based upon her actions, there was no communicated consent.
Right.
So it was up to him to establish in the evidence and a bit of the history with the complainant as to why. And this is an important point. In a case where people have history together,
right,
that may be easier to ground your
like
belief
in this case,
about.
Where she acknowledged giving him mixed signals throughout their relationship.
Right.
Yeah.
Whereas cases with strangers can be a lot different.
Yeah. No, that stood out for me. The mixed signals from the past. I have a fiance, but we can cuddle.
It's very difficult in circumstances where people are unknown to each other, I think,
right,
to establish this. I don't think this unfairly puts a burden on an accused where there's fairly clear evidence that there's no consent. I mean,
Right.
I don't, and we've argued a lot of cases, but honest mistaken belief in consent is a real rarity that we're going to argue.
Right. So to be clear, though, when your defense to a sexual assault charge is consent, saying that you actually had consent, the burden is on the Crown.
Right.
But when your argument is honest but mistaken belief, it does somewhat shift to you. Then you have to show that you took reasonable steps. So it is a bit of a shift
It's a shift, but it makes
in
sense,
that
like Joe
particular
said.
defense.
It is, but in a lot of cases it will arise, and this is important. In a lot of cases, based upon the factual matrix, the defense may argue consent. In other words, the Crown can't prove lack of consent, but if that is established, then there's still the defense of honest mistaken belief in consent.
It can be an alternate argument.
Right. We've never really done that or had a factual matrix that we thought that was a plausible argument.
wouldn't say
With the
never.
alternate, you mean?
We haven't. When we've run,
I can think of one.
Honest mistaken belief
Where
in
you've done
consent.
both?
Where it's like, there was consent, but if you find that she
If
didn't
you find
consent, that
I think it was-
we did.
was it one?
A young guy. We did
Oh,
have,
okay, yeah. But I think, again, the thrust of our argument now was that there was consent.
They
Consent.
found there was consent.
Yeah.
So we went on the first argument. Yeah.
But this was, I think, one of the rarities, if not the only case where we argued right off the bat just honest mistaken belief in consent. What is reasonable steps then? Right? So I think this is where you really got to dive into it, is
It gets very nuanced.
what is reasonable steps? So what is the evidence that you can rely upon to inform why the accused believed their honestly mistaken belief? Therefore, what are those reasonable steps? And of course, it will depend on the circumstances of each case. But you got to be careful. It's like testing the waters. What is that, Diana? Like that comes from
That
another
phrase
case.
really annoys me. That was Moldaver. You put that in.
Yeah, that's
You
disturbing.
can't test the waters, but apparently women can.
Leave that out for now.
We'll leave that out for now. But
You can't push it and keep pushing and keep pushing.
so
Right?
But you
that's
can't-
exactly
but,
what
you know,
I was gonna
testing
say.
the
I had a
waters
really
is an
good point
issue.
to make.
Right. No, I know.
Re-ask the question because I got carried off and carried away thinking
So
about
what
Moldaver.
are reasonable steps? What are reasonable steps in circumstances, knowing that you can't test the waters?
Okay, so the point I wanted to make is really interesting because it is historically and culturally common for women to make men take the first step, and they will give subtle little signals.
Well, yeah,
Subtle
the
signals,
dance.
and because women don't like to be rejected, right? Men get used to it because you grow up having to learn to deal with rejection, but women don't like it, so they make men make the first step.
And they don't like to be the aggressors.
And
That's
so,
cultural too.
So that's why this whole signals, right? What were the signals, the nonverbal signals you were getting? That makes it way more complicated because women typically, not always, because women are getting a little more aggressive, but
Right.
but quite often their signals can be really subtle, and so conveying those and explaining those can require a lot of skill.
So you can't test the waters, but you can test the signals. Like, what does that mean? How do you know for sure?
Right? You got to just...
What is reckless? What is not reckless?
Well, that's the question, is what is reckless? And so this becomes an issue in terms of dealing with the explanation, and this is why it's so important for people to testify when they're
have to
accused of sexual
testify,
assault.
right.
They must testify because they need to explain their perception of what was happening.
Right.
And maybe they were wrong about what was happening, but they have to be able to explain effectively and efficiently
Right.
why it was they believed certain things.
That's right.
Right.
So the article is interesting. Like it's a complex sort of written article, but I think the only point we want to talk about it is to debate: does this shift an unfair burden on an accused?
Well, I think we agree it doesn't. No.
I don't think it does, where you have fairly clear evidence that there is lack of communicated consent.
Right.
But one can imagine that if the overall burden is for the Crown to establish lack of consent beyond a reasonable doubt, why do you have to call it reasonable steps and then sort of muddy the waters as to what that is, as opposed to just testifying about, well, these things happened. As a result of these things happening, I believed I had consent. Do you know what I mean? So this is a very this is a very structured defense under the criminal code.
Right.
And totally understand why you get rid of the discriminatory concept that passivity, or is
well, they didn't say no.
Yeah,
that can't be an
that's
argument.
completely bullshit. That doesn't work. But one might argue, and I think somewhat is argued here in the article, that these codified provisions are too much.
So you don't like the word reasonable?
Well, there's a lot of layers to
It's
this,
open
right?
to interpretation.
You got to take
That's
reasonable steps. There's got to be an air of reality, and then you got to still establish evidence that informs your mind as to why you had honest, mistaken belief and consent. Like, there's a lot of fucking layers to this.
Right.
So you said air of reality, and I just want to make this point as well, because we've had this from Crown in pretrial applications about, things that we want to cross-examine on that our guy's going to testify to. Right. They're not necessarily documents that prove anything. It's just we want him to be able to testify about his version and stuff. And we commonly come across the Crown saying there's no air of reality, and the reason given is because the Crown says she says something else happened. Therefore, there's no air of reality.
So your guy's stuff
to his
makes no
version of
sense
events.
based on what she says. Well, that's not fair.
That's a fallacy. That's wrong.
Yeah. Right.
So in this case, this was an argument. Well, frankly, you're right. So the Crown argued in this case, you can't argue, and this is wrong, and we talked about this in the previous podcast we did. You can't argue honest, mistaken belief and consent if the parties diverge on what the facts are. Yeah. So in other words, complainant says this is the series of events. The accused says, no, this is the series of events. Right. If you have an opposition in the facts, you can't argue honest, mistaken belief and consent.
Diametrically opposed here.
Yeah, right. That's not true at all.
He's permitted to tell his version of events.
Right.
And it can raise a reasonable doubt.
Right. In
and
and
of itself.
believed.
If he's
we
believed.
said that at the same time.
Right. But so you can absolutely argue honest, mistaken belief and consent if there's, opposing a version of events.
Right.
But again, the reasonable steps aspect and the air of reality is like straddling a baseboard. It's not that hard. You just have to basically
especially a pretrial phase.
Yeah, you have to basically just show that there's some reasonableness to what you're actually arguing, and it's a very low threshold. But when you talk about the reasonable steps, it gets very muddied, as opposed to, and I think.
So what do you think the test should be?
Well, I don't like the reasonable steps.
Okay, so give me a replacement.
I'm living with it. Well, nobody's going to do that, so it's not even worth it. I would just say the accused has to point to, evidence.
Actual actions
actual
or events
evidence
or words.
Actual evidence of actions or words that then led to his or her honest, mistaken belief and consent.
Right. And this is interesting, too, because...
Simpler.
Because we've talked about, it's different if you're strangers or if you have an ongoing relationship.
Right.
So sometimes that's why prior sexual history may become relevant, where otherwise you'd be like, well, what does it matter? You're only accused on this date.
Right.
But sometimes those prior interactions lay the groundwork for the way consent was being communicated later in the relationship based on patterns.
History,
And,
That's right.
and agreed upon signals and communications.
That's exactly right. So one can imagine that if people are relatively unknown to each other, it's very hard to point to certain things that would then give you a certain belief, because your time with this individual is extremely limited. Your knowledge of how they behave or communicate consent
is non-existent. Almost, yeah.
Very, very hard in those circumstances. And so one again might argue, well, that shifts an unfair burden on an accused. Well, no. You just, you may have to be a bit more cautious if you're with somebody who's a stranger. And that's what the case law says.
So of the cases you've done, they've been known to each other, right? I think most of the cases.
Mostly.
Right?
I mean, I think the cases where people were relatively
we have had some
unknown.
where they were just like a first date kind of thing.
We've had a bunch of first date cases, but those are consent cases. They're not honest, mistaken belief and consent. And one of the cases that we had where the co-accused basically should have argued honest, mistaken belief and consent because there was some legitimacy to that was because they had spent several hours together. So it wasn't just they had spent 5 minutes together. They were at a bar, they were drinking, they spent time together.
You didn't grab her in a back alley by a bus stop.
Yeah, they went to some other location, then they eventually wound up in an apartment, then they're playing games, and then they're drinking and they're talking. So there were many hours that they were together.
Playing darts.
Right. There was a lot of contact to draw upon. That wasn't our circumstance. Right. Most of our circumstances, and I think when you're dealing with people who are on the first date or just having met each other at a bar or whatever, it's really a consent situation.
He says, yeah.
So here, just to give some meat to what we're talking about, is this was a situation where people had had known each other for over 2 years.
There's an existing professional relationship
That's right. There was a professional
With
relationship
mixed signals.
with mixed signals.
where they were friends for over 2 years and had often touched each other intimately, both privately and publicly. This physical contact included hugs, close dancing, and hand-holding. They would often touch each other affectionately, but not directly on any particular intimate area of the body, but stroking an arm,
Right,
stroking the
right.
face, stroking the
And
hair.
actually walking across campus with holding hands. Like, you know, that's...
Right. On one occasion, they spooned, laying beside each other while alone on a bed. At all material times, they each were romantically involved with someone else.
Well, she said she was engaged.
Well, and him at that time
him,
also had been
right.
with someone. You know, and as you said, for example, they had held hands
In public.
walking together, and very close dancing.
Right.
And in fact, on the day in question, there were a lot of actions that were very similar to what they had done in the past. So on the day in question, they held hands earlier in the night, walking in the presence of other people. They had engaged in their intimate, fun type of dancing, like they had done in the past.
We're not talking just signals. We're talking physical interaction, which is important.
That's right.
A physical closeness
Right.
that leads you to believe the person's interested in you.
When they were sitting on the couch later on in the night, they both were intoxicated, but she was curled up, leaned into him in a very affectionate, intimate way.
And his hand was on her tummy, I think. That's
correct. That's correct. So there were a lot of...
There was some dispute between the two of them as to where his hands were at what
Well,
time.
his hands-
Yeah, I mean, she disputed some of this, but some of this came out in cross-examination. She had no choice but to admit.
Right.
The brilliant cross-examination of Jessup Newberry.
Thank you so much. But there was a history and actions that you could ground your belief in. And that is where the reasonable steps came out. And in actuality, it wasn't that I thought it was reasonable. I hate to use that term, but because I didn't like reasonable steps.
Reasonable
right.
steps.
The
But
steps
you know,
he doesn't
it
like.
really wasn't. It wasn't insurmountable. Like I was like, all this made sense.
Well, I was going to say the same thing. I read it, like, this is your case,
Yeah.
but when I read the fact, I said, okay, it makes sense. Like,
It did. It did. So
one thing led to another.
And that's why I believe in a case where it's pretty clear on the facts that there is no consent. So if you're dealing with one of those stark cases,
Right.
you know, like if there's a history there, I don't know if it's that onerous to establish this evidence. I just find the concept of reasonable steps in and of itself is a complicated term
Right.
that doesn't translate well into what does that mean by way of the evidence that you have to elicit.
True.
I think it's good to point out too is like in this particular case that we worked on, she was very upset and she felt violated by the touching that took place, and that doesn't go away just from the fact that he was wrong in thinking that she was agreeing to it. The reality of where we're going with this type of defense is to say you shouldn't put somebody in jail for making a mistake.
Right.
And this is kind of an interesting...
And this
you
was
know,
a
thing.
gradual
This
escalation
defense-
in terms of contact,
This
right?
defense of honest but mistaken belief is a mistake of fact, where the person honestly believed that the person was consenting and they were mistaken in fact.
Let's go a little bit farther for a moment. So reasonable steps means that the person has to do something active to check in with the person that they think everything is cool, right? So if you're not allowed to test the waters, what happens? So in a case like this, if we recall the evidence, this is where the parties diverged, okay? So if I remember correctly, and I think it's articulated here, that there was certain contact between them that established reasonable steps to him. So, you know, he would look into her eyes as he touched her shoulder, and then had his hand on her tummy, and
she smiles back at him
and
from a
smiles
certain
back
amount of
as
touching.
they're cuddling
Yeah.
and holding each other.
Right.
There's a kiss made and there's a smile afterward. You know, so there's movements and facial expressions that he describes that would then assist with determining that reasonable steps had been taken. But it's not an
A
actively...
reasonable person in that situation would have
That's a
maybe
better
come to
way
the
of
same-
explaining it, right?
to the same conclusion.
Reasonable steps seems to connote that you're doing certain things to make sure you're getting consent.
Active
But
steps.
you're not.
Right.
That's not what it is. This is not an artificial checkbox. Right.
Well, it
That's why I have
sounds
a
like
problem
it.
with reasonable
Yeah,
steps.
no, I agree. It sounds
Is there
like
a
it.
reasonable basis to determine that there was communicated actions perceived by the accused that therefore led to a belief of honest mistaken belief and consent. I mean,
Many
I'm
people,
just making it
maybe
up on the
not
spot.
all, but
Yeah.
many people would have interpreted those signals in the same way.
Right. So I think I could articulate a test a little better than that, than just saying reasonable steps.
Articulate
I
again.
can't right now. You'd have to really sit down and craft it out. It's just the reasonable steps I find it's like, well, what steps did you take?
Well, yeah, I was
Well,
going
the
to say.
Supreme Court's declined to actually outline what those steps are expected to be.
It's very
Well, thank God that's true, because I got to be honest, as much as maddening as it may be, you can't create a list.
It's artificial.
It's because
Because people are so different
Right.
in the way they communicate.
that's right. But I think it's important for us to get across to people who may be confused about this. And we get this question often by clients when we're discussing what an honest mistaken belief and consent is she was holding me. She was touching my face.
She was looking at me
She
in a
was
certain
looking
way.
at me in a certain way that meant to me something a lot more than that we were just having a nice moment
She
as
started
friends.
sucking your finger.
Don't go there.
But there are actions that mean something
Right.
to the accused.
Right.
That's what we're talking about.
Yeah.
Yeah.
It's not actually taking a step.
No.
It's actually
Tick box, tick
there
box,
are actions
yeah.
upon which your interpretation may be falsely held, but it was honestly held.
Right.
Yeah.
So I think once we move away from that unfortunate language, I think it becomes much more clearer.
So to be clear as well, like there's certain elements for sexual assault. It requires proof by the Crown of 3 elements. 1, touching. The touching was of a sexual nature.
Right.
And that there was an absence of consent. So the Crown has to prove those 3 elements in order to convict somebody of sexual assault. Right? So, but then in terms of honest mistaken belief, we get into the mens rea, which those first 3 steps are actus reus.
Right.
So the mens rea requires
Mental
two elements, that the person had the intention to touch the person and knowing or being reckless or willfully blind to a lack of consent.
Right. So when we deal with this case of honest mistaken belief and consent, which is the only issue, all the actus reus is established and frankly admitted.
We
Right?
don't dispute that.
And part of the mens rea is admitted as well. It's frankly, I fully intended to touch her, but here's why.
Here's why.
Was it reckless or was it an honestly mistaken belief and consent?
Right.
And that's the issue. But the article was very thought-provoking, and it's a recent article. I mean, it was just published this year.
Yeah, just in November.
Just in November. So I think it's a thought-provoking, well-argued piece. I don't think it'll lead to any legislative changes.
Not anytime soon.
It may
no.
be helpful in interpreting a little bit about how you go about evidence.
And that's so important, the interpretation is because legislation is passed, and then what that legislation means is largely established by how the courts decide to interpret
yeah.
it.
That's right. So this can be a guide, if anything.
So let's talk about the article so people know if they want to find it.
Sure.
Mirroring mens rea, the 2 pathways to conviction argument in Canadian sexual assault law. The author's last name is Mano, M-A-N-O.
It's on Canley, everyone.
2024, Canley Docs 2572. I think it's an interesting piece of writing that I think is thought-provoking and can get you to think about it. But I think what it does actually, for those of us who've been through these cases over
A few years.
many years,
A few years.
it just gets you thinking about the evidence a little bit more. I don't think this will lead to any sort of change with the legislation, of course not. But I just think it's helpful to sort of hone in on what evidence is legitimate for this type of defense.
Yeah, and like I mentioned earlier too, is like this type of defense, honest but mistaken belief, can actually be one of the primary reasons why you need to be able to talk about other sexual history in certain cases, because people can develop
point.
their own methods of communicating when they're looking. I mean, we had one client. He was actually saying the signal, because she was kind of shy. The signal was wearing high heels inside the house. And that was actually a signal.
Oh, that case. I remember that case you guys had.
There can be some really weird things that are really unique to people.
Well, not weird. It's just different.
It's not weird.
It may not be common to us, but everybody has their own
signals, language.
Couples have their own way of interaction. But that's an excellent point, Diana. You can imagine in a case where you are arguing honest mistaken belief and consent, either as your primary defense or as an alternative defense, that if this is a couple over some period of time, sexual history is highly relevant.
Well, the defense needs context.
But there you will get an argument back honestly, you'll get an argument back. So how's it relevant to honest mistaken belief and consent? To me, it's obvious. Like it's
The couple has developed a
signals.
language.
This is
It's a
this is their own
language. It's
internal
their own
language.
language.
But which is why when we draft these applications, we say this goes to how they communicated consent.
Right.
And that goes to the defense of you can't establish lack of consent or honest mistaken belief in consent.
Right.
But this underscores something very important, particularly in this type of case where there is a relationship, either husband and wife, boyfriend, girlfriend, whatever. That history or that other sexual activity is highly important.
Well, it's a dictionary to their relationship.
It's a good way of putting it.
It is. It explains it.
Yeah.
I like that.
Nice.
All right, well,
All right.
So hopefully we explained that a little bit better than we have before.
I think we'll tackle it again, when we
Well,
come up to it.
keeps
but,
coming back, this issue. Yeah.
It's an important one to go through. So good night, guys.
Good night, good night.
Thank you again for your viewership and all your support, and frankly, the questions and comments, which are great. You can do
Read the
pillow talk. Do pillow talk.
Don't forget to like, comment, subscribe, share.
Yes.
We do read the comments, and
Yes, we do.
appreciate everybody who follows us, and
Any
shares.
questions, you email us, you do it on whatever we're on, and it's helpful. We read it and we pay attention to it. So good night and thank you very much. Good
Thank
night,
you.
everybody.